Subcommittee on Capital Markets, Insurance, and Government-Sponsored Enterprise will come to order. Pursuant to committee rules, each side will have 20 minutes for opening statements. Without objection, all members' statements will be made part of the record.
Paul, I don't think your mic's on.
It isn't. Can you hear me now? Still off? Can we hear? Okay. Okay. Well, I get a chance to say good morning again. Today we meet to examine. Oh yeah. Okay. Okay. In order to convenience the caucus and this committee, will recognize the chairman of the full committee for his opening statement.
I thank the chairman of the subcommittee. Let me ask, people have asked, apparently there was a Democratic caucus going on, but having invited a number of very busy people to a hearing, I think it would be inappropriate for us to either cancel this or delay it, so we are going to go ahead with this. This is a very important subject. The Supreme Court has made a decision that many of us dislike. I must say I was struck at the sensitivity of the Chief Justice. Since he's not here, I can comment without further wounding his apparently delicate feelings. But he was quoted as saying that he thought it troubling that he had to sit in a room full of members of Congress who were cheering a criticism of his opinion. And I trust that that sensitivity does not translate into his First Amendment rulings going forward. The notion that people should be constrained about criticizing a Supreme Court ruling in the presence of a justice is not one that I have a great deal of sympathy for. But our purpose today is not to criticize the ruling, a little side thing we may do, but that's not our purpose. It is to, in an entirely appropriate and constitutional way, occupy the space that the opinion leaves for appropriate regulation. The court has ruled that corporations have certain rights, but I guess if we were to follow the Declaration of Independence, if they are endowed by their creator with those inalienable rights, since we are the creators of corporations, because they get their form from law, we can put some rules here. And the purpose of this hearing is to, in an entirely constitutional way, as I say, explore ways in which we can, in my view, protect the political process from a further dilution of the one-man, one-vote principle by money coming in inappropriate ways. What we are talking about is disclosure and shareholder voting. I believe what we are doing is entirely constitutional and within the spirit of the opinion, and I think we are talking about ways that we can, and in my judgment, what the Supreme Court did undercuts the democratic process. I think we are reducing that. But even people who were all for the decision don't necessarily have to be against this bill. What we are talking about here is a matter of corporate democracy and of corporate governance. And what we have done, and I think the gentleman from Massachusetts and the gentleman from Florida, Mr. Grayson, who's worked with him, and Mr. Capuano from Massachusetts and others, have come up with a very appropriate way to make sure that democracy is protected and the integrity of the electoral process is protected. And I thank the chairman of the committee for calling this hearing, and this is something we intend to move on. Mr. Chairman, I appreciate your recognizing me.
Chair recognizes Governor Castle for 5 minutes.
Thank you, Mr. Chairman. And I would like to thank, obviously, all the witnesses for being here today, and I appreciate you holding today's hearing. Corporate governance is a very important issue to me and to this committee, obviously. In my home state of Delaware and across the country, corporations are a major source of economic activity. And in this economy, when we must remain focused on job retention and job creation, we must be especially careful when considering proposals that would alter 150 years of state corporate governance laws. With that said, I believe that Congress must act in response to the campaign finance restrictions overturned by the Citizens United versus FEC case. This ruling now allows corporations and unions to spend unlimited funds from their general treasuries and campaign advertisements targeted at a specific candidate. I was one of 4 members of Congress who filed an amicus brief prior to the ruling asking the Supreme Court to uphold the laws that long prevented corporate and union spending from being a deciding force in the political process. For this reason, I have introduced a bill with Representative David Price from North Carolina called the Stand By Every Ad Act, which extends the Stand By Your Ad disclosure currently required of candidates in political advertisements to CEOs of corporations and the union leaders. I believe this is a targeted response to the Citizens United case. I look forward to listening to the testimony of the witnesses before us today. We know there's a lot of other legislation, and I'd be interested in your comments about that. And again, thank you all for being here. We look forward to the hearing. I yield back, Mr. Chairman.
Mr. Castle. Good morning. Today we meet to examine the likely effects of the Supreme Court's decision in Citizens United versus the Federal Election Commission. In response to this groundbreaking ruling, members of Congress have introduced no less than 30 bills. While other panels in the House have jurisdiction over many of these measures, the Financial Services Committee has the responsibility to examine these bills related to shareholders' rights and corporate governance. Like many, I was disappointed in the Supreme Court's ruling. In our system of capitalism, corporations enjoy many benefits designed to promote the efficient allocation of resources in a variant economy. Unduly influencing elections should not be one of those privileges. Moreover, shareholders have financial interests in companies, not political interests. Finally, I should note that in our political system, people vote. Corporations lack such rights. To limit the influence of Citizens United decision, the Capital Markets Subcommittee now has under consideration several proposals. Those thoughtful bills generally aim to increase shareholders' participation in the electioneering decisions of public companies, enhance public transparency on corporate campaign spending, and contain corporate political activities. At the very least, we ought to act to empower shareholders to determine whether and how corporations can spend their money for political purposes. Shareholders should not expect that a company will use their money to invest in candidates that the shareholders themselves do not support. In this regard, corporate management should obtain some form of approval from their shareholders regarding corporate campaign expenditures. We also ought to enhance public disclosures of corporate political expenditures. Many have said that transparency is the best disinfectant. Better information about how corporations spend their money on political activities will help to hold corporations accountable for their actions. Today, we will examine pending legislative proposals introduced by Mr. Ackerman, Mr. Capano, Mr. Peters, Mr. Grayson, and Ms. Kilroy that achieve these desired ends. We will also explore ways to refine these bills. I look forward to a vigorous debate at this hearing so that we can determine the best way to move ahead on these important policy matters. Moreover, because we have many ideas concurrently in motion, I am also hopeful that we can work today to achieve consensus, improve coordination, and ensure a comprehensive legislative reaction. In sum, while courts have long granted corporations a status of personhood, they are not actually people. We need a legislative response to the Citizens United case in order to restore the balance in our democratic system, and corporate governance reforms represent an important facet of an effective solution. Such reforms can give American citizens, the living, breathing, voting people we are here to represent, faith that our system of representative democracy will long endure and thrive. Mr. Capuano was recognized for 3 minutes.
Thank you, Mr. Chairman. First of all, I want to welcome the witnesses today. My hope is that we've been working on this original draft bill for a while now. We've actually taken out some of the provisions I think some of you might be concerned with, that I was concerned with, relative to this numbers of votes specifically by shareholders and the like. And I hope that you have a chance to look at the redrafted bill soon to get further input. I think we've addressed most of the concerns that some people might raise, that I had myself. And of course, what this bill is exactly what has already been told. The bill is an attempt to do what we can do within the limits of the law, not without impeding anybody's First Amendment rights or rights to gather or anything else. When I was in law school, I was taught that corporations had three basic rules: use somebody else's money, make a profit, and keep both. My understanding is that the Supreme Court has kind of expanded that just a little bit more, and I respect that. I may disagree with it vehemently, but there's not the first Supreme Court ruling I have ever disagreed with, and I have no doubt that it will not be the last. At the same time, that does not mean that we should not then have an appropriate and thorough response to it to the best of our abilities, knowing full well that someone will bring something to court again. That's why we have this system. We do what we think is best to the best of our abilities without intentionally breaking any laws or violating the Constitution, and have those attempts tested in court. And that's why we're back today. We had thought we had fixed this once, and apparently we didn't, and now we'll try it again. And so I'm looking forward to hearing testimony today and ideas as we go forward as to what it is that we can do, knowing full well that some people think that we shouldn't do anything, and I respect that position. I just strongly disagree with it. And I'm even open to suggestions by people who do disagree with this. I'm not trying to intentionally stifle corporations, though I would like to. I make no bones about it. My preference is lost in court a few months ago, and that's life. At the same time, all I want now is, if that's going to be the case, the question then comes is, whose money is this that corporations can now use? And the answer is, it is shareholders' money. That's whose money it is. And if that's their money, if they choose to be involved in politics, fine. Now, I would love to get to a situation where we could have it only direct money, and I would love to be open to that idea, because I would love to have ads on TV against me saying, don't vote for Mike Capuano, he's a horrendous guy, brought to you by the Exxon Corporation. That would be perfectly okay with me. I can't get there yet, and I haven't found a way to require that just yet, so I'd love to hear ideas on that. But in the meantime, we're going to do the best we can to come up with a bill that is constitutional, yet thorough and clear, to make sure that what the free speech has now been given to these transparent yet fake organizations, at least responsible to those people who own the money, which is shareholders. So with that, Mr. Chairman, I yield back my 1 second.
Thank you very much. It's my pleasure to introduce the panel and call for their testimony. I want to thank the entire panel for appearing before the subcommittee today, and without objection, your written statements will be made part of the record. You will each be recognized for a 5-minute summary of your testimony. First, we have Professor John C. Coffey, Jr., Adolph A. Burrell, Professor of Law, Columbia Law School. Professor Coffey.
Thank you, Chairman Kondrowski and fellow congressmen. My message is going to be very simple. Congress cannot really fight with the Supreme Court or with the scope of the First Amendment. What Congress can do, what Congress should do, and what I would say Congress must do, is increase the transparency and accountability surrounding corporate involvement in the political process. The best means to that end is to use Congress's unquestioned power over the federal securities laws, and particularly the proxy rules, because that already is an established system of disclosure that is widely used and relied on, and only modest adjustments are necessary. The goal, however, has to be not only to increase transparency and disclosure, but to give shareholders an effective remedy by which to challenge decisions of which they disapprove, because this is a world in which shareholder and managerial interests are not well aligned. There may be perfectly legitimate corporate contributions, but for every dollar contributed by a corporation to maximize shareholder wealth, there are other dollars that are contributed to pursue the personal, political, or ideological agenda of senior managers, and all of that is hidden. It is hidden because we today have an election contribution system that works through conduit organizations, typically trade associations and others, and there is no obligation for the corporation to disclose non-earmarked payments to trade associations, even though they're perfectly aware and are actually told by the trade association that these payments are substantially going for political and electioneering expenses. Okay, so our focus, I think, today is on implementation, and what would I suggest? First of all, I would ask the SEC to form an advisory committee to re-examine its disclosure rules. We have the annual report on Form 10-K, the quarterly report on Form 10-Q, and the proxy statement, all of which are providing shareholders a rich range of information, but absolutely nothing today about political contributions or contributions to conduit organizations such as trade associations. Here, you don't need legislation. We need to prod the SEC to put something else on their rather busy and overcrowded agenda. That's step one. Step two, we need to give shareholders an actual remedy that allows them to contest the decision once it's brought to light. And here, there's a problem that Citizen Union just ignores. It assumes that shareholders have practical remedies by which to contest decisions of managers to make contributions. In fact, they have very few rights. What can we do? As a corporate governance specialist, let me tell you that there are always really three basic options. You can give shareholders a right to sue. I'm not recommending that. I think it would be largely futile, but others can suggest that. You can give shareholders increased voice. And increased voice means a right to vote on specific proposals that are focused on a particular company situation and what's been disclosed about that company's behavior. Next, you can finally give shareholders a right to exit, a right to sell their shares if they are dissatisfied. And that right only works if they are given specific disclosure about what contributions have been made, how they have been made, what the process was within the company for approving these, and what the rationale was. Now, most importantly, what I would tell you is that to really give shareholders an effective remedy, they must be given an enhanced right to vote. Classically, the right to vote in this field was implemented through shareholder-approved bylaw amendments. For generations, shareholders have had the rights in virtually every state to adopt bylaw amendments that could regulate anything in the corporation's business and affairs. Such bylaw amendments might, for example, 1, require a committee of independent directors to approve all political contributions and electioneering expenses. 2, it might require that there be a report annually to shareholders of what the purposes were, what the justifications were, and what the process was for the contributions that were made. And 3, bylaw amendments might prohibit certain kind of payments that are not really related to the company's line of business or to the goal of shareholder wealth maximization, but appear to be related to social issues. Whether it's same-sex marriage or abortion, either side of these issues, there's no real nexus between those issues and shareholder wealth maximization. Such bylaw amendments do not have to obtain a majority vote to be effective. There's a lot of experience here, and the moment you have a bylaw amendment that can get a 20% shareholder vote and can be put up in the next year, management will come in and negotiate, and you'll get a practical solution between the shareholders and the management, because no management wants to have a quarter or more of its shareholders dissatisfied. So once these issues can be put on the agenda, then we'll get a practical resolution. That's been the experience in a lot of areas with shareholder bylaw proposals. But there are 2 major obstacles, and they are both new, and this is where implementation really hits a rocky road. First of all, there's a major state law problem, and secondly, there's a major problem with SEC rules as they are currently interpreted. The major state law problem is a decision a year and a half old called CA Inc. versus AFSCME, which is a Delaware Supreme Court decision a year and a half ago, and it says that shareholder power to amend the bylaws can never intrude upon, encroach, or interfere with the power of the board of directors to substantively direct the business and affairs of the company. It's an old tension, but this is a new decision, and it has really curbed the power of shareholder bylaw amendments. This is an area where I think Congress could add a simple, modest provision to the federal securities laws and the Securities Exchange Act of 1934 that could be limited just to bylaw amendments dealing with corporate political activity and electioneering expenses, giving shareholders a uniform federal rule, because this is not an area where we want state-by-state variation, so that shareholders of any public corporation could adopt a bylaw amendment restricting or curbing or otherwise influencing corporate political behavior and shareholder corporate election expenses. The idea here would be to give a continuing right to adopt bylaw amendments, because if we only have one vote up front, the problem is we'll get a blanket authorization that the shareholders will vote forward in order not to cripple the company. But we want our specific amendments from time to time that are focused on what the company is doing. Now, that's the state law problem. Now we move to the SEC's problem. Shareholder voting basically depends today on one SEC rule called Rule 14A8. Shareholders can place an issue on the corporation's agenda. The issue might be a bylaw amendment, or more typically, the issue has been a shareholder request to get an informational report. So shareholders may request the board of directors to report to them about the company's behavior and activities in the political process and election expenses. That's been a technique that's been used for 20 years or more. But something new has happened. In the last year, year and a half, the SEC has fallen back on several broad, ambiguous exemptions under Rule 14A8, and it has ruled that the corporation may exclude shareholder proposals seeking more information about the corporation's involvement in politics or in campaign contributions. It may do so, the SEC staff has ruled, at a very low level at the SEC, because there's a broad exemption in 14A8 that says shareholders may not make proposals that relate to, quote, ordinary business operations, close quote. A very ambiguous phrase, ordinary business operations, and the staff has said that any proposals dealing with lobbying or political contributions are really dealing with ordinary business operations. Frankly, I think that's symptomatic. If we say that the company's involvement in politics or in campaign contributions is only ordinary business operations, we are assuming a giant conclusion without information about what is really going on. Thus, I would suggest that this committee can prod the SEC to re-examine these broad and ambiguous resolutions. The truth is that under 14A8, the SEC staff once took the position that broad bylaws, the broad policy saying the company would not hire or retain any employee who was gay was a matter of ordinary business operations. Over time, the SEC became embarrassed by that position, and Congress prodded them to re-examine them, and now they have ruled that any kind of discrimination is not a matter of ordinary business operations. I similarly think that their position that political campaign contributions are always ordinary business operations is overbroad, undesirable, and has to be reversed. Until it is reversed, we are not going to have corporations, shareholders have an effective remedy by which they can prod and push the company to take stronger, clearer positions. Okay, so I'm suggesting really there are three things that should be done in conclusion. One, Congress can prod the SEC to re-examine its disclosure rules, which is a continuous disclosure system involving the 10K, the 10Q, and the proxy statement, and have a section in each that describes what the company is doing in its political operations. That's something that the SEC can do without legislation, but it's got to be prodded because the SEC has often got a very full plate and isn't looking at these issues today. Next, I think Congress should prod the SEC to revise and narrow its overbroad exemptions under Rule 14A8. There shouldn't be any concept that ordinary business operations includes political contributions. Okay, lastly, and I'll stop here, most ambitiously, Congress could amend the Securities Exchange Act and give the shareholder the right to adopt bylaw amendments that would limit corporate involvement in political and electioneering expenses. Then, and only then, would the key premise to Citizens United, that shareholders can take effective action, would become accurate. Thank you.
Thank you very much, Professor. Now we have a little bit of a dilemma. We have about, 10 and a half minutes left, and I want to give you all the time in the world, since we allowed the professor to run over a little bit. Did you want to take your 5 minutes now? But we'd have to limit you to no more than 6 minutes because we'll have to make a vote on the floor.
I will happily try to summarize my testimony in 6 minutes.
Okay, then we'll recognize Mr. Carl Sandstrom of Counsel, Perkins Coie. Mr. Sandstrom.
Chairman Ken Jaworski, Congressman Castle, Congressman Capuano. I thank you for the opportunity to appear here today to testify on an issue I think of great importance. And I will summarize my testimony and request that the public opinion polls that I refer to be made part of the record. When Citizens United was first argued, the issue before the court was whether Citizens United was required to disclose the corporations and other contributors who paid for the advertising and broadcasting of the film. The argument was made to the court that disclosure was likely to chill giving by corporations. Many corporations, the court was told, prefer anonymity. They did not want to be associated with controversial issues like climate change and financial regulation. In an 8-1 decision, the court rejected this argument and found that disclosure was essential to the ability of shareholders, and more generally to the public, to monitor management's use of corporate resources. Justice Kennedy wrote, "With the advent of the Internet, prompt disclosure of expenditures can provide shareholders and citizens with information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pocket of so-called moneyed interests." When the case was re-argued, the issue that was added to the case was whether corporations enjoyed the same rights as citizens to spend unlimited sums promoting or opposing their candidates of choice. One argument that was made to the court against extending that right to corporations is that dissenting shareholders would be forced to underwrite spending in support of a candidate that they personally opposed. The court rejected this argument, finding that the government's legitimate interest in protecting shareholders could be achieved through strengthening the rights of shareholders through corporate governance. The court found that there was little evidence of abuse that cannot be corrected by shareholders through the procedures of corporate democracy. This decision stands for two propositions that are particularly relevant to this committee. First, disclosure served important governmental interests, and second, corporate governance is the means that the court envisions as being available for companies to be held accountable for their political spending. If transparency and accountability in the wake of Citizens United is to be more than a mirage, Congress will need to act. Current law is not up to the task. Corporations cannot disclose to shareholders what they do not know. Current law encourages companies to rely on outside groups to do their politics. The less the company knows about the political spending that it finances, the less likely it will be publicly associated with that spending. The more involved a corporation is in making an expenditure, the greater the likelihood that it will not need to be disclosed. Current law perversely creates incentives for corporations to remain ignorant regarding how their money is spent. The first step is to require corporations to be made aware of how corporate funds are used. Corporations should know and in turn inform their shareholders and the public when corporate money is being used to support or oppose a candidate. Unless a corporation is provided with the necessary information, it should not be allowed to contribute to an outside organization that engages in politics. Persons using a corporate donation to pay for political ads should be required to disclose its spending to the public and to the donating corporation and confirm that the corporate donors approved of the use. Transparency is insufficient without accountability. Substantial political expenditures should require shareholder, at least at a minimum, board of director approval. The approval needs to be specific and not general. The shareholders and the board need to know what candidates are being promoted or attacked with corporate funds and why the spending is in the interest of the corporation. If the shareholder approval is required, an institutional shareholder should not be allowed to sit on the sidelines. An institutional shareholder needs to independently evaluate the proposed spending and determine it is in the best interest of its beneficiaries. In conclusion, only Congress can provide the protection the court suggests that shareholders are entitled. Therefore, I would urge this committee to accept the court's challenge and bring transparency and accountability to corporate political spending.
We're so well organized right now in the House that we can have a conference going on with the Republicans, the Democratic caucus going on at the same time, and have a quorum call called. So you can see we're really on track here to get the House well organized and on its way. And unfortunately, in the middle of this hearing, we have the pending quorum call. What we're going to do is take a 15-minute recess so we can record our votes, and then we'll come back and pick up with the further statements. So with no further ado, the hearing will stand in recess for 15 minutes.
I think we're several witnesses. Yes.